Hi, this is Robert Chisholm from Chisholm & Kilpatrick, and with me today is Barb Cook, also from Chisholm & Kilpatrick, and today we're going to be talking about military sexual trauma cases and how they're handled at the VA. Can you tell us how VA defines military sexual trauma?
Sure. They define it as a psychological trauma that results from a physical assault or battery of a sexual nature, or a psychological trauma that results from harassment, sexual harassment, which they in turn define as repeated and unsolicited verbal or physical contact of a sexual nature.
So when we started handling these claims in the early days, let's say in the early 1990s, I used to think of MST and PTSD as MST really as a subset of post-traumatic stress disorder claims, but they're not really, are they?
I don't think so, and I think that the VA still primarily, perhaps exclusively, considers them that way. But in fact, it's any psychological trauma. The diagnosis does not have to be post-traumatic stress disorder or PTSD. It could be depression, it could be anxiety, it could be, as I said, any psychiatric or psychological diagnosis. In addition, it could be a physical diagnosis that results from the psychological trauma.
Are there any particular challenges that a veteran faces who was the victim of a sexual assault in service?
Absolutely. The survivors of these assaults frequently do not report them. And one of the requirements for VA is that in these cases, as well as in many cases, the underlying event has to be established as having occurred. It's not enough simply to show that one has the diagnosis. One has to show that the diagnosis is related to something that happened in service while the person was on active duty.
So let me ask this question. If these events are not typically reported, and one can imagine why they wouldn't report them during service, how does one go about establishing that the trauma actually occurred?
VA recognizes this problem, and so it does have special rules in terms of MST cases that explicitly instruct the adjudicators of these claims to look beyond the military records. And the individual's failure to report the event at the time, and the fact that the incident or incidents are not recorded in the person's military records cannot, as a matter of law, be used against the individual. Instead, VA allows the person and instructs its adjudicators to have a very wide range of ways of trying to show that the underlying event occurred. These can focus on changes in behavior at the time, changes in social behavior, such as becoming more reclusive, changes in economic behavior, getting into debt. It can be requests for transfer when there's not really a basis for it. It could be substance abuse, alcoholism, all changes in behavior in terms of being less productive at work. The examples are broad and non-exhaustive. It's just any possible way of showing that the person was affected by something. She or he may have reported it to a friend, a relative, a minister, and those reports could happen at the time of the event, or it could happen later, particularly, for example, if the person is in therapy and starts to recall or is able to describe what happened.
So you said a couple of important things here, if I could just review. So let's say a veteran comes to you and serves, say, in the 1970s, and let's say that they were a victim of a sexual trauma, but there's no evidence of it specifically in the service records. That is, it wasn't reported. And let's say that the service records show that the veteran's performance dramatically dropped after after service. Would that be a marker or something that the VA could rely on to show that possibly that was the reason?
Yes, absolutely. And one of the other things that VA allows in these cases is that a VA therapist could look at that information, and that therapist could say then, yes, this is evidence that this event occurred. And VA can use the therapist, the mental health professional's statement as the proof it needs to show that the event actually occurred. Again, even though it's not reported in any official record.
The other thing you said when we were just talking was that it could happen to a woman, obviously, but it could also happen to men. Is that correct?
Yes, absolutely. The VA itself estimates that approximately 50% of the claims are filed by men.
And are there any specific rules with reference to confidentiality of how these claims are processed by the VA?
Well, the VA has confidentiality rules that apply to all of its claims. No one has access to them, with limited exceptions, to the information in the records. That's true at the regional office level. It's true at the Board of Veterans Appeals level. When the cases are filed at court, sections of the claims file are also filed as part of the court's docket. And those are also confidential. Those are limited in terms of who has access, members of the court, the attorneys or advocates representing the individual. In MST cases, in addition, it is possible at court to ask the court to seal the record, which means that no member of the public would be able to see any part of the pleadings filed in court. And it is also possible, and we have done this successfully, to ask the court to permit the survivor to pursue the claim under a pseudonym, such as Jane Doe, or under initials, not the individual's initials, but just made up initials, so that the record, again, is not accessible to anyone other than members of the court and counsel.
Do you believe that the VA, with this regulation that they now have, is adjudicating all these claims properly?
No, I do not. I think that they make mistakes. I do think, as I indicated before, that they often narrowly limit the types of diagnoses that they would consider proper for this consideration. I think that they don't always look as expansively as they might in terms of what evidence of behavior changes, or what other evidence, not just behavior changes, but things like a person getting a pregnancy test or getting a series of pregnancy tests or testing for sexually transmitted diseases, things like that, which can all be evidence that shows that the individual did suffer at the time. So no, I don't think that they do. They also tend not to look at reports from non-VA healthcare providers, which is one of the things that claimants can be helped with, is getting a non-VA healthcare provider to actually review the records and make this assessment that can then help show that the diagnosis is related to the underlying event.
One last question, if I could, and that is, let's suppose the veteran is denied their claim at the regional office. What do you recommend?
I recommend that they appeal it. I also recommend that they get the help of a experienced and trained advocate to help them negotiate through the system. It's a long process. It's a challenging process. The VA's paperwork can be very confusing, and it helps to have someone who knows what they're doing to get through the process.
Is there anything else you have that you want to talk about in terms of these MST cases?
As with all claims, I feel that the VA compensation is a contract that we have as a nation with people who serve. And this is not a gift. This is not something people should be reluctant to take advantage of. We cut a deal with people who volunteer and who do serve that says if you are injured on active duty, we will help take care of you. And that's what this is all about.
Thank you, Barb. This
Thank
is
you.
Robert Chisholm and Barb Cook from Chisholm and Kilpatrick. Thank you.